What happens after someone dies with a last will and testament? Have you ever wondered what happens when someone passes away and leaves behind a last will and testament? It's a process that involves several important steps to ensure their wishes are honored. Let's break it down. First, the original will needs to be located. This document must be properly executed, meaning it was written, signed by the person who made the will, and witnessed according to the laws of the state. Typically, the will names an executor, who is responsible for managing the estate after the person has passed. Next, the executor files the will with the probate court in the area where the deceased lived. This is known as probate, which is the legal process that validates the will and oversees the distribution of the estate. The court checks the authenticity of the will to ensure it reflects the deceased's intentions. Once the will is filed, the court formally appoints the executor named in the will. This gives the executor the legal authority to act on behalf of the estate. Their responsibilities include gathering and protecting the estate's assets, paying any debts and taxes, and distributing the remaining assets to the beneficiaries as outlined in the will. The executor must then identify and take control of all assets owned by the deceased. This includes real estate, bank accounts, investments, personal property, and other valuables. These assets are inventoried and appraised to determine the total value of the estate. After that, the executor notifies known creditors and publishes a notice to unknown creditors, allowing them to make claims against the estate. The executor pays valid debts, administrative expenses, and any taxes owed before distributing assets to the beneficiaries. Once all debts and expenses are settled, the executor distributes the remaining estate assets to the beneficiaries according to the instructions in the will. This could include outright gifts, trusts for minors or those unable to manage their own affairs, or other arrangements. Finally, when all duties are completed, the executor files a final accounting with the probate court and requests to close the estate. The court reviews the executor's actions and, if everything is in order, formally closes the estate. It is also important to note that the will may include provisions for guardianship of minor children or care of pets, which the court will consider during probate. If the will creates trusts, the executor or trustee will manage these according to the terms set forth. Proper execution of the will during the person's lifetime is essential to avoid disputes. This includes signing the will in the presence of at least 2 witnesses who can confirm the person's capacity and intent. A self-proving affidavit, notarized at the time of signing, can simplify probate by affirming the will's validity without needing witness testimony. So, when someone dies with a last will and testament, the will guides the legal process of probate, ensuring that the deceased wishes are followed and the estate is settled properly.